Okay, I would like to welcome you all to our very first Child and Child online Rights of Light clinic. You have, of course, many of you I see from the attendees list attended the clinics which we've had in our offices in the past. Sadly, of course, that's not possible today. Neither is a glass of wine at the end. Now, we have a panel who I will introduce you to very shortly. But firstly, I would just like to speak briefly about the format for the webinar. Now, we're going to have a number of questions which will appear on the screen, which the panel have seen beforehand. And what I would ask the audience is that if you have any question in respect of one of those questions which come up, then please click your raise a hand button, and then at an appropriate point during that question or towards the end of that question, I will unmute you so that you can ask that question. So without further ado, I would like to introduce you to our panel today. We have Andrew Francis from Searle Court. Andrew is an expert in rights of light and has written the textbook Rights of Light, Law and Practice, and he has been instructed on some of the big rights of light cases in the past couple of decades. Then we have Alistair Redler from Delver Patman Redler, and again, Alistair is a recognised expert in this field in both rights of light and related neighbourly matters. And last but not least, we have Andrew Smith from Child and Child. And again, Andrew has many years of practice in rights of light and party walls and related matters. So what I will do is I will move on to our first question, which, there we go, should now appear on the screen. The first question is, and I'll read it out so everyone's got it. I act for a developer who has taken out an insurance policy against rights of light claims. The policy says that the developer must keep the insurance arrangements confidential and must not disclose them to any claimant in court proceedings. Action is now being threatened against the developer by a neighbour whose light has been infringed, and I have been asked to disclose any available information about whether my developer client has taken out insurance. Am I obliged to do so? If not, would I become obliged to do so if court proceedings were issued? So I'm going to put this over to our panel, and can I ask that Andrew Smith starts to address this one?
Yes, well, first of all, on the question of insurance, the existence of an insurance policy obviously has no bearing on the value of the claim. The insurance relationship is entirely between the developer and the insurance company. Insurers are understandably very coy about disclosing the fact that they're involved, because dominant owners are therefore likely to think there's a nice pot of money and the case will more easily settle. So more often than not, a rights of light policy will say that its existence must not be disclosed, and which is fair enough. And the surveyor certainly has no authority at all to break that confidence and to disclose the fact that a claim is insured without the client's authority. Of course, there are ways of finding out. And the way I try to find out is to say, well, I'm proceeding on the basis you got insurance for this. And usually the nature of the answer to that question is going to give you a pretty clear idea whether it's insured or not. So it's quite easy to draw a reliable inference about the existence or otherwise of insurance. So no, there's no obligation to disclose it. The rights of light surveyor cannot be compelled to disclose it until court proceedings are issued. Now, court proceedings will almost invariably be for a claim for an injunction or for damages in lieu of an injunction. And the question of the likelihood of an injunction being granted is a very important question. And that's a question which the judge is going to have to answer in the light of all the circumstances. It is obviously a very relevant consideration that the developer has got insurance for a claim. So for that reason alone, the existence or otherwise of insurance policy is clearly relevant to the claim and documents relating to that issue must be disclosed if asked for. Secondly, the insurance policy is relevant to the state of knowledge of the developer. If as a developer, you've got an insurance policy, then it's pretty obvious, you know perfectly well that what you're about to do is likely to infringe somebody's rights. In other words, the existence of an insurance policy helps the dominant owner to demonstrate that the developer went ahead with the development with its in the knowledge that the dominant owner's rights would be infringed, and took the prudent step of insuring against that contingency. Thirdly, in the context of the exercise of the court's discretion as to whether or not to grant an injunction, one of the questions the judge must ask himself is, would the grant of an injunction be oppressive to the servient owner, to the developer? Well, if the developer has already paid a premium for his insurance policy, and if the developer isn't going to have to cough up very much money for taking down the development, then clearly an injunction would not be oppressive from the point of view of the developer. So for all those reasons, although insurance has nothing to do with the value of the claim, highly relevant to the question of the exercise of the court's discretion as to whether or not to grant an injunction. And it does surprise me that in very few cases has there been a proper ventilation of the existence of insurance policy and the effect of the existence of insurance policy on the exercise of the court's discretion in granting an injunction. I think that over time is going to feature as a more prominent fact to be considered when an injunction is being sought. And you could say, in fact, that if a developer has taken out insurance, then that fact alone, to an extent, makes it more likely that an injunction will be granted, because in performing his evaluative weighing up exercise, the judge must take that into account. And one can conceive of circumstances where a judge, in borderline cases, where a judge might say, well, this poor developer is going to be ruined. If an injunction is granted, and that is just about enough to tip the balance in favor of refusing an injunction. But if on the same facts, the developer had a nice fat insurance policy, a different conclusion might arise. An injunction might be granted. So policies are fully disclosable, in my view, in litigation, not before. I'm not aware of any fight, any case in which there has been a fight about the disclosability of insurance policies. But if there were a fight, then, as I say, the document is relevant to a matter in issue, and therefore the documents ought to be disclosed. That's how I see it.
Thank you, Andrew. Sorry.
I'd be interested to know from Alistair what proportion of his cases do carry insurance. I know some are not insured for one reason or another. My own personal impression is that the vast majority of developers do take out insurance. But Alistair's impression is more reliable than mine because he's got his feet on the ground.
Yes, I mean, I think the majority of cases end up being settled with some insurance policy, though increasingly it's the agreed conduct policies as well now. So negotiation is taking place, but with a policy behind it.
Yeah.
And of course, that is still just as confidential. So I think so. I think there are obviously surveyors who are recommending insurance more often than others, depending on their perceived risk. And I think one of the factors that changes it is the solicitors involved, because some specialist solicitors in the field are much more cautious about the insurance policies and the way they'll stand up if properly put under stress than others. And I think that has an effect then on the client's decisions. But no, I think the majority do. And to answer the question on it, I think from a surveyor's point of view, it's simple. You do not say anything about the insurance policy at any point. You can only do so with client instructions, and the client may only be able to give those instructions having spoken to their lawyers and the insurers. So the surveyor must not do. On the flip side, though, we can normally tell. If you ask a surveyor the right questions about what the information and how the building's affected, if they go away and need a day to come back to you to respond, it probably means they've gone to consult with insurers, and we normally spot that. So, and it's not really affecting how we negotiate. I don't think surveyors are saying, oh great, they've got insurance, let's milk it. But it might mean that you know that there is a case to pursue and you'll negotiate properly.
Andrew, are you aware of any cases where there's been a fight about the relevance of insurance?
No, not in the context of rights of light or party walls or anything like that. I agree with everything that's been said before. I just wanted to add 3 comments really to the general views that have just been expressed, and I agree with the answer that Andrew and indeed Alistair have given to the question. There are of course invariably 2 sides to a claim, and often there will be 2 insured parties. I find that quite frequently when I'm acting for an intended claimant, seeking, for example, to restrain a breach of rights of light or breach of covenant or anything, first thing I ask them, certainly if they're ordinary folk, ordinary householders, is what legal expenses have you got in your household buildings policy? And they go away and search in the loft for it, and lo and behold, there is sometimes something in there. Whether it's going to do them any good or not and up to the limit that's stated is one thing, but it can be very helpful, albeit that they may be shuffled off without any disrespect intended to a firm of panel solicitors who may not really be able to deal with it. But sometimes, again, the right amount of pressure on the insurer will get them to the right firm like Child and Child, and the right light surveyor like Mr. Redler, and the right barrister like Mr. Francis. But anyway, that's another story. But so you've obviously got that bit of the insurance spectrum. You've also got the developer's indemnity policy covering the very risk that has come about. And again, I do quite a lot of work on that for some of the called bespoke insurers and or brokers, where a lot of my advising, whether it's covenants or lights or whatever, is invariably going to be hawked around to see if somebody can get a policy. And if the policy is in place and then the litigation comes along and there's a claim obviously made under the effectively engaging the risk terms under the policy, then of course the last thing you ever do is disclose the fact that there is a policy behind you. And you have to be terribly careful, as Alistair said. You don't tell anybody. And it's only if you're asked, like say, though, the right question, and only after litigation effectively as part of a disclosure, that the point about somebody's status as an insured may come out. I have to say that degree of ignorance here is displayed because I haven't, for many a long year, more than 40 years, ever even done anything, probably not until not since bar files, on road traffic collisions, where of course insurance and the availability of insurance, where it's insurance third party compulsory, whatever it is, and then you've got non-insured people and the ultimate insurer of last resort, the I can't remember what it's called now, the
Motor Insurance Bureau,
insurance board. What happens there in litigation? But anyway, be that as it may, the third or second point I was going to mention was that the other point that comes up from time to time, and again it's relevant to what Andrew's just been saying about the facts and matters that would be within the, or ought to be within the knowledge of the court. On an interim application, if the claimant wants to get his interim or her interim injunction, he or she or it will have, of course, to provide that thing known as the undertaking as to damages. In other words, he or she will have to show that he or she will be able to answer the costs, not legal costs, but the consequences of a delay if it turns out at the end that the final injunction or any injunction was not properly to be granted on a permanent basis. And indeed, we had this, Andrew and I, on opposing sides a very long time ago.
And indeed, Angela and I on opposing
and Angela
sides
and I,
as well.
we all had this in the famous case of Regan in 2005, where in fact there was a secondary judgment on the undertaking as to damages that Mr. Regan had to give as a consequence of him getting the interim injunction before the final trial. And that is where sometimes the insured status of the claimant will of course be very important. Because if the claimant says, well, I've got an insurance policy with an indemnity limit up to £1 trillion, then I'm going to be good for the money. And that's where he, she, or it may have to disclose the policy and therefore would have to get. And of course, the important point, as I know Alistair and Andrew will know, and everybody else in this virtual room will know, of course, you work with your insurers and you tell them what's going on and ensure that you don't put your foot in it so that they can void the policy. So it's keeping everybody informed of what's happening. Certainly after a claim has been made, you have to be absolutely upfront with everything that's happening. So that's all I have to say really on that point, but I agree with everything else that's been said.
Okay, well, thank you, panel. I think if there's no other comments on this one, I think we should move on to our next question.
There are no questions from the audience on this one.
There aren't any. None have come up. No, nobody has raised a hand at the moment.
We must have answered very comprehensively. We've done a good job.
Indeed. Okay, so our next question for the panel is: my client owns a flat which has acquired rights of light by prescription. Her light to the flat has now been significantly reduced by a development over the road. She objected to the application for planning permission for that development on the ground, amongst other things, that it would interfere with her daylight. Permission was granted, however, and the offending building has now been up for more than a year. My client has only recently found out about the possibility of bringing a rights of light claim. But when I contacted the developers, they said she was too late to bring the claim based on prescription because the property had been up for more than a year. Is there anything that she can do? Can I ask you, Andrew Francis, to kick off with this tricky question?
Yes, this raises the thorny question in cases where there are prescriptive rights, and this is presumably what this is about, as we know, the thorny question of the relation back of time under Section 4 of the Prescription Act 1832. What's not commonly known, at least outside our little world, is that when you're asserting a right of light under Section 3 of the 1832 Act, the time runs back from the time when the right is brought into question. And that can be one of three events, or must be at least one, can only really be one of three events. The date on which a claim form is issued, not served, but the issue date. The date on which a counterclaim is served, raising for the first time the right of light question. There may, for example, be a claim which raises a right of way or covenant question, and it's only in the counterclaim by the defendant that the right of light, prescriptive light, is brought into question. And the third is the reference by the Chief Land Registrar to the First Tier Property Tribunal, Land Registration Division, under Section 73 sub 7 of the Land Registration Act, which is the thing that triggers the reference of the matter to the tribunal. And there's a relatively recent case of Judge Cousins about that, which is in the books. Now, until and unless that event has arisen under Section 3, the claimed right of light is inchoate. In other words, it hasn't yet formed itself into anything of any formal shape. It's a sort of bit like an amoeba. And the 20 years that you claim under Section 3 runs back from that notional date. Now, what you therefore have to show is during that 20-year period, running back from, say, the 12th of May 2020 to the 12th of May 2000, that A, the light's been enjoyed continuously, so it's got to, you've got to show that the window's been there and it hasn't been bricked up or whatever. And sometimes you have cases about where, for example, in Oxford Street, there have been permanent store show cards in the windows. You can say, well, you haven't been enjoying your light above the first floor level. So continuous enjoyment, no consent, so there's no agreement. Thirdly, it's something which is obviously open because it is open anyway, because we can see it, where the aperture is there. And thirdly, without interruption. Now, interruption is a period defined by Section 4 of the Act, which is that there is no period of at least a year or more than a year or more, whereby the right has been interfered with or obstructed, or the light's been obstructed without any complaint by the dominant owner. Now, that's important for a number of reasons. First of all, if you therefore simply grumble to your rights of light surveyor, you go along to Mr. Redler and say, Mr. Redler, my lights have been interfered with and I don't like it. And they've been interfered with since last Friday or something. Unless, Alistair, or indeed if somebody goes along to grumble to Andrew Smith about it, or even to me, unless we then tell the other side that this has happened and we object to it and we assert our lights, if that objection doesn't get itself known to the other side for a year, then frankly it's too late. Now, there is a little question here which has never entirely been resolved, at least to my satisfaction, and I'm just looking for my copy of the famous book which I've just got behind my screen. Based on a case in the 1880s. It's all about, well, what about having, you've got to have notice of the obstruction. There's an old case called Seddon and the Bank of Bolton in 1882, which is in all the books. Well, this, of course, Section 4 presumes that you've had notice of the obstruction, and there's a bit of a discussion about this in all the relevant books. And the question is, well, should there be some definite thing on the new wall saying this has been put up by Stiggins and Co. or something like that? Because the question is, have you had notice of the interruption for the year? I think we joint authors in our book take the view, and I think the newer books published by or written by Jonathan Carris and Michael Barnes and indeed Gale, which is effectively Miss Justice Morgan and Jonathan Gaunt, are all really very much of the view that there shouldn't have to be a notice saying this has been put up by Mr. Biggins. So the answer is, in this case, that if there hasn't been an objection, even a letter written saying I object within the year of the potential issue of the claim form, it's too late. And the classic instance of that was in a case called Dance and Triplow nearly 30 years ago in 1992, where Mr. Dance complained bitterly, and I think it may have been to John Anstey, I can't now remember the facts exactly, where he complained bitterly to his right of light surveyor, and I'm afraid, or his solicitor, but the solicitor and or somebody else didn't take the initiative and write the objection, as it were, or send the objection, even a letter, to the person who'd put up the extension to the house. The other point I would just say finally is that it's very important when you're running your time back and considering the year interruption. There's two other things that are absolutely critical to this. The first is, and we don't want to get too deep into this, the first is, of course, as certainly most of us would know, if not all of us would know, a light obstruction notice is deemed to be an interruption. So if it's not been objected to, in other words, challenged effectively by the issue of a claim form, then you're too late. And I was involved in a case against actually Stephen Bickford Smith in 1995, the Bowring against Scottish Widows case, where Scottish Widows were putting up, Bowring were putting up a new building. And we were also proposing to put up a new building, we Scottish Widows. This was all down Lower Thames Street, just at the end of Eastcheap in the city. And we served and registered all the relevant rights of light notices, light obstruction notices against Bowring, and they did nothing about it. And then just after the expiry of the year, and it was also slightly complicated by the fact that there'd been an emergency application, or first registration, emergency registration, temporary registration, just after the year from the date of the temporary registration in the City of London Corporation's registry, they popped up with their claim form. In fact, I think in those days it was still called a writ. And we said, you're too late. There's been an interruption within section 4. And then there was an argument before Mr. Justice Lloyd about whether or not the time ran from the temporary registration or from the permanent, and he held it ran from the temporary registration. But the other significant features of that case were, first of all, that because they had lost their section 3 rights, and therefore they were out of time because they'd been in interruption by the law for the year, or more than a year, they were then forced, and I'll come to this in a minute in this question, onto lost modern grant, because the alternative way to do it was for me to say, well, I can prove my 20 years, and it actually could be before the building went up or was finished or whatever, and therefore I'll rely on lost modern grant. Now, as some of us may know, and certainly I know, in that case, the Bowring case, lost modern grant didn't run because of the custom of London, which says that within the bounds of the City of London, there's an ancient custom that says you can build in or ancient foundations to any height, and therefore there's no fiction. There can be no fiction of the lost grant. So in that case, the failure to spot the passage of the year was absolutely fatal. And Bowring, we got before Mr. Justice Lloyd, Bowring's claims struck out as a breach of whatever it is, the rules, and a whatever it is, we call it a vexatious claim. Now, in this case, let's assume for the moment that in the question the flat is not in the City of London, and therefore not subject to the custom of London. The lady could acquire, or rather assert, a right of light based on the fictional grant of lost modern grant, which, as we all probably, I'm not sure know, but may recall, is based on a fictional grant at some time within the last or before the expiry of 20 years. In other words, sometime before, it could be the 12th of May 2000 or any time before that, when the grant was possible, or put it another way, not impossible. For example, during common ownership, you couldn't have it during common ownership of the dominant and servient land. It doesn't matter that it's a fiction, because it's an ancient fiction that goes back to the 17th century, which was designed to get rid of the problem of people having to show enjoyment since September 1189, which was the commencement of the reign of Richard I and the commencement of legal memory. So all of that causes shudders amongst many people, particularly my clients. But in short, the joy, if that's the right word, of bringing a lost modern grant claim, or being able to do so, means you're then not foxed by the 1 year that has been the delay period or non-objection period. I just mentioned one final very practical point. It's this: the start of the period can be earlier than the, or the 1 year can be earlier than the building itself. Can be the erection of the scaffolding that will be often higher than the existing building during the demolition works, because they need to protect the health and safety of all around. So you may start getting, especially when the scaffolding's got effectively sheeting on it, which is going to be not translucent. So you will then get the obstruction to light starting at an earlier date from when the building, the new building, came up physically above the ground to the heights at which it's going to be causing the interference. And we had this, and I don't recall now how far it's dealt with in the judgment, but I think it's mentioned en passant in His Honour Judge Langan's judgment in the Heaney case some, Lord knows, 10 or more years ago now. So watch out for scaffolding. And I actually had this round the corner from Child and Child's new offices at the new Grosvenor Estate development at the top of Hyde Park Corner, where I was advising the Grosvenor Estate. And at that stage, the Lanesborough was going through some sort of refurb, and the presence of the scaffolding on their land was also relevant in some way, I can't remember exactly how, to either their rights or our rights. So don't forget the scaffolding, because that's very important. So the answer to the question is, lost it under Section 3, outside the City of London, lost more than grant, but the time can start from when scaffolding and other things go up. That's as far as I think I can take the question. Thank you.
Brilliant, thank you, Andrew. Can I open that out to the panel? Do you, Andrew Smith, have anything to add in there?
Well, I'd say it's much the same as Andrew Francis in a slightly different way. This 1 year period is very confusing. There is a common misconception, I find, that once a building has been up, once the interruption to the light, whether by scaffolding or by the building, has been there for 12 months, then prescriptive rights cannot be pursued. Because, as Andrew said, the combination of Section 3 and Section 4 of the Prescription Act. As Andrew said, an obstruction is only fatal in that sense if the obstruction has been acquiesced in. And I think that's the key point in this scenario. The question is, has the obstruction been acquiesced in? Once it has been acquiesced in, then it doesn't matter how long the interruption is, therefore prior to the issuing of proceedings, because the obstruction doesn't count. And acquiescence means submitting without protest to the state of affairs. And it doesn't take very much to demonstrate that you do protest. As Andrew said, all you've got to do is to complain to the developer that your rights of light have been infringed. This is a bit of an oversimplification, obviously, but that, generally speaking, is enough to demonstrate that although there has been an interruption, the interruption has not been acquiesced in, acquiescence being the key element of it. Obviously, the protest has to take place within 12 months. It's no good protesting afterwards and then saying you're not acquiesced. So in this case, the question is, what has the flat owner done to indicate that she does not acquiesce in the obstruction? Well, she did something. She did something even before the building was erected. And it is established that it's perfectly possible for your protest to occur prospectively before the interruption took place. What she did was she opposed the planning application on the grounds that it would interfere with her daylight. So the question is, would that count as demonstrating that she has not acquiesced? Does that qualify as a sufficient protest to the servient owner? And as Andrew astutely pointed out, the answer is no, because all she did was protest or oppose the planning application to the local planning authority. That on the basis of the case that Andrew mentioned, Dance and Triplo, is not enough to qualify as a protest. And therefore, she is just about on the wrong side of acquiescence in this case. And so I think a year's gone by, the obstruction has been there for a year, there's no acquiescence, she's lost her prescriptive rights, she's only a lessee, so she can only rely on prescription, can't rely on anything else. So it's game over, I'm afraid, so far as that claim is concerned.
Okay, well, thank you very much for that, Andrew. Now we have one additional question on this from the audience. So as this is very much a legal matter, I'm just going to open that up now to Richard Nosworthy, who's raised a question, so he can ask the panel. Richard.
Hello. Yes, just in the case of Davies versus DuPaver in 1953, the courts did determine that although the claim came forward after 12 months, they still held that there was no submission or acquiescence to the loss. Are you able to comment on that, whether there is a 12-month period or it can extend slightly beyond that?
I didn't hear the name of the case, I'm afraid.
Yeah. Davies
What was the name of the case, Richard, in 1950s?
It's in your paragraph, Andrew, 826 and 827 in your model.
I didn't hear the name of the case.
It's Davies and DuPaver.
Yeah. Yes. So, sorry, what's the question?
So when we discussed this matter, it was that the party would have deemed to have acquiesced if they hadn't brought forward a claim within 12 months. However, in that particular case, I believe it was around 13 months before a claim came forward. But the courts determined that they hadn't submitted to the loss or acquiesced to it. So I believe that there was an injunction was withheld. That was granted, sorry.
Well, I don't have the facts of Davies and DuPaver in front of me for obvious reasons. I think the point that we make in the book there is, of course, implying a state of mind, as was said by Lord Justice Birkett in that case, as the foot of page 126, paragraph 8.26 arises, and therefore, without going into 1953 Queen's Bench, which I don't have immediately to hand, I would need to look again at what state of knowledge or mind there was in the relevant parties. And as you probably know, Richard, from the recent decision in the in the Supreme Court last year on the 54 Act Part 2, the intention point when you're opposing renewals of 54 Act Part 2 tenancies, states of mind and states of knowledge could be vitally important there, and you will no doubt know of the review of the authorities on that in that context by the Supreme Court last year. I'm not entirely sure quite how it. I mean, in this case, the tenant objected to planning consent, so she knew that there was a proposed development. In terms of what happened next, obviously we don't know, because the facts, obviously, the question are very brief, rightly so. In a case where the claimant here, or potential claimant, the tenant, has actually objected to it on the grounds of, planning consent objection, well, I would have thought she would be treated as knowing about what's going on. As I say, I don't know quite what happened in Davies and DuPaver as to what they did or didn't know, and I'm very happy to look it up on Westlaw later and have a look at it, Richard. You're at Wilson's, and I'll happily send you an email with any further thoughts on it. But we've already expressed a view in our book there, the joint book, which at the top of page 8.26, and then over to paragraph 8.27. As we say, a knowledge point, becoming aware of the obstruction. If you're aware of it, as I'm sure she would have done, because it was probably outside her windows, then whether you've acquiesced is then a further question of fact. And as I and Andrew Smith have said, then the question is, what do you say? What have you said? Even a short email to the developer or owner saying, you know, we don't like this, we object to it, would be enough. But I think you've exposed a good point, Richard, if I may say so, which is, of course, what did the claimant know? I think that's the point, unless I've misunderstood you.
Yes, I think it's just really whether you can strictly apply the 12 months and actually taking it a step further, would the objection at planning be deemed as an objection, or does that need to be made direct?
Well, I think the answer to your two questions is as follows. You would be very ill-advised not to object within the year, or not to advise on the basis that unless there has been an objection within a year, that probably has sold the Section 3 rights down the river. I think it would be very, very difficult, and no doubt, as I say, you will know of the Supreme Court decision last year on intention and states of mind in the 54 Act context. So that's a very difficult area, and I wouldn't want to be cross-examining somebody in court about their state of mind at a particular time. I think that's a very dangerous area to be getting involved with. And secondly, once you do know, it behoves you or your client or yourselves as advisors to send the shortest even of emails or letters to the other side. And I don't think the planning consent, and I agree with Andrew, I don't think the objection to planning is relevant, because that's not an objection to the servient owner, it's an objection to the local planning authority. So I don't think that counts, but I would readily accept that there's no, as far as I'm aware, there's no actual case on this, but I would have thought that if I was in front of a judge this afternoon, he would say, well, Mr. Francis, your client's objection to planning authority is simply that. It's not an objection to the development. And of course, the other very important point, as we all know, as I'm sure you know, Richard, that civil rights of light are not relevant in planning terms, so they wouldn't be material in any objection anyway. So I think I would be on rather thin ground if I was seeking to advance that argument.
I think if there were a debate about this, the relevant consideration would be more state of knowledge than state of mind. It's very,
well,
very
I'm
similar
taking
to the situation where you have a limitation point, where you judge, where you calculate the period of time from the date when the claimant became aware of facts which would give rise to the suggestion that a claim might lie. And here, I think it's very much the same thing. When did the claimant become aware of a fact? The fact being that the light to the building was being interrupted. And that's a factual matter that judges are well accustomed to dealing with. So I have not had any experience of litigating that point myself, but it would surprise me if it proved to be a difficult point to resolve, because it's so familiar in those other contexts.
Yeah, I mean, I think I'm using the word state of mind advisedly, because I see that we have taken the word state of mind from the judgment of Lord Justice Burkitt's judgment. Richard, I'm very happy. I will, when I have a moment or two in the next 24 hours or so, I will dig out Davies and DuPaver and just, if I may, if you'll allow me to do so, I'll send you an email about it if there's any points that I feel deserve a bit more anxious consideration. But thank you very much for the question.
Yeah, I suspect the judge was using language loosely there, actually.
Well, yes, he was a criminal. Well, we all know that dear Burkitt, Norman Burkitt, was of course one of the he was one of the chief judges in the Nuremberg trials, and had very much more experience of states of mind as a criminal barrister and a criminal judge. So I think rights of light would have been strange to him. But, anyway,
strange to most people.
He was a brilliant man. Leave that there. Yeah. Richard, have we dealt with that question satisfactorily? I hope we have.
Yeah, no, I think Richard's not on speaker anymore.
All right.
More Andrew, but I think thank you very much for that detailed answer. Now, I don't think we have any further questions from the audience arising from question number 2. So what I'd like to do is move on to question number 3, which is, in the recent Beaumont case, there are questions raised over the higher rental values for the upper floors in high-end office buildings. should surveyors be attributing different values for light reductions on a floor by floor basis rather than considering the building as a whole? What are the panel's thoughts on this? And it goes on. B, following Beaumont, can I now insist that my opposite number considers radians when we are negotiating what sums should be payable by way of damages? And I think, given the nature of this question, can I ask Alistair to comment first, please?
Thanks. Yes, certainly. I think to answer the first one, the important thing is to realise why the office rental value was talked about in this particular case for several days, and the three different assessments for value that the court looked at brought to them. So you have the first method, which is what we call the book method, the traditional method, £5 per square foot multiplied by the YP to get to a base number. On the other extreme, we have Tamares, which is a loss of profit of if the developer had to reduce their building to not cause a right to light injury. And in the middle, which was argued in this case, was loss in value to the dominant owner, not as a book value assessment, but the actual loss in value to their property as a result of the loss of light, which is what the book value assessment is seeking to do, but does on an extremely simplistic basis. In fact, such a simplistic basis that the barristers and judges are increasingly reluctant to even put it forward in the court cases, although us surveyors know that it's what we're using as our primary assessment and starting point for negotiations on every job. The reason this is important is that the book value looks at effectively how much of the rental value of the property could be attributable to a light. That's where it came from. And the original ANSTI chart had a scale on it that put a proportion of the rental value as attributable to light until it capped out at £5 per square foot. Bearing in mind this was the late 70s and we haven't changed it since, shows how archaic this is. And that's the £5 per square foot that we use in the book value calculation. Now, Beaumont case looked at something different. They said, what was the actual loss and how do you calculate that? And the problem with that, and the reason the book value method works, is that you cannot easily assess what is the reduction in value caused of light, other than a reduction in value by the mass of the building, how ugly it is, whether it blocks a view, or indeed whether its use is causing a problem. For example, a rival hotel would affect in this case, would affect values the first building. And what they did, and I thought it was quite an elegant solution in the end, and we've used it since on a job to advise our client, is what they said was, well, if the light on the third floor in listing, and then it's changed by the building being taller. So the third floor now has the same amount of light as the first floor previously had. In other words, a two-story building, an extra 2 stories opposite, is reducing the light to the dominant by an equivalent 2-story shift in the height of their building. Then you can say, well, if you've got renovation, that the third floor was renting for X per square foot, and the first floor was renting for X minus a percentage, minus 10% per foot, and there's no difference between them really in the environment, they're identical floors, then you could argue that making the third floor only as well lit as the first floor, that the rental value would be reduced from floor level to first floor level. And that's what they argued. And after much discussion, mostly about the way in which valuation was done and the factors used in it, the judge kind of accepted that approach. Which I think is a fairly elegant one. And as long as there isn't another factor, for example, that it's destroying a view of Tower Bridge that would be valuable to anyone taking that property, making an external space less usable than it would, all these things that would affect value well. So basically that's the argument they used. Interesting was the court effectively abandoned this, hardly look at it really at all. And what they did, the Tamares assessment primarily on loss of it has to feel right. So what he'll do is he'll do the loss of value calculation by that method and see if it was that far different. Well, it was quite a bit different, but the judge said, well, it's not enough to make a difference, therefore we're going with Tamares. It's a third of profit, unless there's a good reason to reduce it down and award it a third of profit. So really what it comes down to is you need to know why you're using the rental value dominant building in the calculation and the assessment. But the bad news from this, for many of us, I think, or good news, depending on who you're acting for, is the loss of profit assessment, again, being dominant as the method of use. And I think we're now in a position where loss of profit is going to be how the courts look at it every time, moderated by whatever factors are relevant to the particular case. And I increasingly see the book value enhanced book method as going away from us. The only one being, of course, if developers don't engage with you on the profitability of their scheme, then it's very hard to pull forward a negotiation meaningfully. And that's why we're still using the book value so often to get to a number suitably enhanced that we think is at least capable of being recommended. It's not an ideal situation at the moment, I don't think.
Okay, thank you, Alistair. Before we move on to the second limb of that, can I ask if Andrew or Andrew have got any comments?
You know, well, I'd say this, that a huge amount of investment in experts and lawyers' fees went into the calculation of the rental loss, which is £20,000 a year with a multiplier of 12, so £240,000 was the rental loss. So it's easy to think that that case was decided by reference to the rental loss calculation. But as Alistair said, it wasn't. That case was calculated, the damages in that case were calculated by reference to the conventional profit share approach, with a Tamar is 30%, 33% for the profit share. And after all that work and expense and effort, the only relevance of the rental loss was to enable the judge to say, well, if I order 33 1/3% of the developer's profit of 1.1 million, we come to £350,000. I'm inclined to do that. Does it feel right? Is it disproportionate? No, it's not disproportionate, because the actual financial loss was £240,000 in terms of the loss of rent. So all that work for the loss of rent calculation was only relevant insofar as it was applied in that cross-checking part of the exercise. And you can't help wondering what the upshot would have been if all that money had been saved and the judge has said, okay, I'm inclined to award 30% of the developer's profit, £350,000. If there was no rental loss, would he have thought that was too much? I suspect not. So we'll never know. It's perfectly possible that those rental valuations did not actually have a decisive effect on the level of the damages that were in the event awarded. We'll never know.
With respect, Andrew, I'm not quite sure I agree with your overall conclusion as to the utility or otherwise of the very expensive, no doubt, and chunky analysis of the rental loss figure. The reason why the judge had to go through the rental loss figure was because he had to consider, first of all, whether or not compensatory damages were to be awarded in the event that he decided not to grant an injunction or could not grant an injunction with damages in lieu. So damages in lieu under Section 50 would only come up, the negotiating damages would only come up if there wasn't going to be an injunction. And so therefore, when one looks at the judgment, he had to say, first of all, has there been a loss? And I'm just looking at the paragraph numbers now by way of a cross-reference, but it's into the paragraph around about, it's just after the assessment of the loss. He then has, the judge then had to consider what I might call common law or compensatory damages were going to be, and that's why we had to spend, or they had to spend so much time on all of that. And there were some problems about causation in the events that had happened as well about the other building that had taken place. But apart from that point, I think it's an important case because, or the point about looking at what I call the true loss, first of all, accords with a view that I've been expressing for a number of years, to some extent, well, not entirely in the wilderness, but I've expressed the view even at your own firm seminars and other places, that this addiction to the £5 a square foot and etc. It's been very, as Alistair said, is historically nearly 50 years old now, and out of date and out of place. And this notional uplifting is completely unformed. And indeed, a judge said in the Scott Namuwu case some nearly 5, 6, 7 years ago now that was not the appropriate way of looking at damages. So we can throw all that out of the window. And indeed, as also appears from the judgment, the counsel on both sides of the parties disclaimed any reliance on the £5 a square foot. They said, we don't want to go there. Let's just start by looking at this properly. So I think, as Alistair said, we do now have to do this properly. And the elegant solution, by taking the sort of better floors as some sort of guide to the less better floors, might well be one way of looking at it, although in residential contexts, I'm not entirely sure how one does it, because we don't really have any true rental values. The other point that really comes in here, and it's not dealt with in this case, at least as far as I've been able to work through it, and again it does come in in residential cases, is that it does throw also up the point, which a lot of us have made many times, is on the question of what we call parasitic loss. Seems to me that, again, if we're looking at a true loss figure and not just slavishly looking at the £5 a square foot on the contour diagrams and the EFZ tables, that it seems to me we are entitled to go back to first principles and say, look, what about true parasitic losses? And I think there's a question actually at the end of this seminar today, which I think does in fact raise that right at the end of question 5. So perhaps we'll park that one up for the moment, but that's all I really want to say about part A of question 3.
There is one other thing I can just quickly say about, you mentioned parasitic losses. One thing that makes a difference by us going on to tomorrow's and loss of profit is it doesn't matter. Parasitic losses become irrelevant.
Yeah.
All that matters is what is the angle, the shallowest angle that you need to put across the neighbouring building, the developer's building, in order to leave no right to light injury. So all that matters is which single room in the dominant owner's building causes the biggest angle cut, and you put those together, and that is where the loss of profit comes from. So we're putting everything back onto the loss of profit, and maybe only moderating that by how many rooms and how much of the building is affected to see what seems reasonable. Parasitic losses become not an issue. So in fact, while this complicates matters by putting it in the realm of valuers more than traditional building surveyors, it also simplifies some elements of it as well into straightforward modelling, as opposed to worrying about some of these legal issues. So it's quite a sea change in rights of light assessment coming through on this.
Now, during the course of this discussion, there has been some from the, I think 2 different members of the audience have put on their raise a hand and have taken it off. Now, I'd like to put this out to questions from the audience. If either of those individuals who did put their hand up would like to do so again, I will then unmute you and let you ask a question, or indeed anybody at all from the audience, if you have a question you'd like to raise. No, it would seem that you've answered it.
It's like we're doing a very good job.
Indeed. Can we move on to the part B of that question?
Yeah, shall I start on that then?
Yes, if you would.
On the radiance. Radiance came up in this, was put forward. It seems that the judge discounted it fairly quickly in his written decision. Radiance is interesting. We're using radiance. Everyone's using it now as part of our arguments. The radiance has some major problems, though. So you can try and insist the opposite number uses radiance, but I would suggest it doesn't do any good to demand more and more analysis unless it's for a purpose. One problem I have with radiance is that it deals with things like reflected light off third-party buildings and within the dominant owner's building itself. And the whole thing with an easement is that an easement has to be capable of being subject of a grant. In other words, you have to be able to impose the restriction on the servient owner. So you can, with a negative easement such as this, you can say the negative owner can only build a structure of a certain size and height, and beyond that, it will cause interference with the easement to the dominant owner. But how do you do that when you're relying on third-party assessments, like reflected light and colours of finishes and so on other buildings, to assess whether there's an injury caused? You're not actually, that's not actually something you're imposing on the dominant specific, on the servient owner specifically. So I think it's an issue the radiance properly applies. The other radiance on a practical sense is it's a very, very pretty colour graph. However, on all the programs, you can set the gradient of the colour pattern. All you need to do is to set the gradient in a way that looks for your case, in whichever way, and that can sway the image of it, certainly when used in a court, which I think is a dangerous. The final point, are we looking for where in a room you can see one lumen of light? Because we're dealing with real light here, not sky visibility as far as it's portrayed. So it has to be one lumen of light. And one option which we've done, which is to basically black out everything below one lumen of light, so we can actually show the one lumen contour. So if you're going to use it, that's a way to use it. I think radiance is a bit of a red herring still, a lot of the time. And I would suggest that it's most useful when a case is heading towards litigation and the legal team want to use it and think they have a case for it, then from a surveyor's point of view, that's where we should be doing the best job we can. I would suggest that surveyors shouldn't be jumping into just demanding it off their counterparts, because I don't think it's going to materially lead to settling it by negotiation using radiance.
Thanks, thank you, Alistair. Andrew, can I ask one of you to comment from a legal perspective on radiance at all?
Well, I agree. It's a very vague test. It's becoming quite fashionable now. I think to a certain extent, it's a new toy that people can play with, and they can't wait to get their hands on it and do their radiance, their false colour images and so on. Certainly, it played no decisive role in the Beaumont case. Jerome Webb gave evidence. His evidence was accepted by the judge, but only to the extent that it demonstrated that the amount of light had fallen. So it didn't add anything to the debate. It's all very subjective and immeasurable, and I can't, in terms of litigation, I can't see it ever getting off the ground. It's only natural for any litigant who wants to grasp at any straw that might be available to bolster his case. But I think we'll wait for a long time before a court decision, is materially affected by radiance measurements.
Yeah, I agree with that, and I agree with everything that Alistair said, and also looking at paragraph 154 of the judgment, where the judge deals with the radiance considerations that were put forward by Jerome, then, and Jerome may well be in the audience for all I know, so he will know more about it, but it looks as if the other side, and I think the judge couldn't really make much sense out of some of it, difficult to tell some of these images recalled in, as human response images, etc. The more substantive point, and of course we also come in here with, as I'm sure Alistair knows, the climate-based daylight modelling, where we have something possibly a bit more sophisticated than radiance, but I'm never entirely sure. It's another load of science which can be hard to understand. The other important point, which I think was a point that Alistair was making a moment ago, is of course the nature of the easement is simply to have light received to a certain quality. It imposes a burden on the servient owner not to build so as to, or to do things to interfere with that. But the one other thing that comes in when we're looking at reflected light and other things, treatment of finishes and colours of finishes, is of course you wouldn't have necessarily, as the dominant owner, any absolute right of control over colours, finishes and other things on the servient building, because as we all know, positive covenants, etc., very difficult to run with the land. And whilst we see lots of Victorian covenants about white glazed bricks and everything else, and keeping them clean of soot, doesn't really help. So the problem with radiance is it does rather impose a burden, an extra burden on the servient owner, which of course is not going to be almost literally reflected in real life. So I think we're right, if I may say so, having been slightly sceptical over many a year, but ultimately persuaded by the rationality of the science and the simplicity. I think we stick with the Waldron model.
I think if you had to rationalize it, you'd say that the benefit of it is that in the circumstances of a particular case, given the radiance analysis, the loss of light does not result in the room being less, whatever the expression is in Coles and colonial stores, less
beneficial
for the ordinary notions of mankind. So it would come in at that point, demonstrating that yes, there is a loss of light, but look at the radiance under these circumstances. There's no, according to the ordinary notion of mankind, there's still enough, so there's no injury. That would be a logical way of trying to apply it. Yeah. But as I say, I think it's a long way off.
Thank you, Andrew. Now, I think there's some interest from the audience in this one, so I'd like to put it out to the audience and ask anyone who has a question if they'd click their raise a hand so that you can then put your question to the audience. Okay, and we've got a question from Aidan Cosgrove, so I will open the mic to him now. So over to you, Aidan.
Thank you, Angela. Hopefully you can hear me.
Yes, we can hear you.
Just on that radiance point, I don't have the judgment in front of me, but I think in the Bowman and Florala case, the judge confirmed that reflected light should be excluded or ignored in assessing the interference of light to the dominant owner's building. And if that is the case, then whilst of course you could still use radiance as a means of calculating the light, if you were using radiance to do so, you would then simply apply matte black, non-reflective finishes to the external environment and potentially also the internal environment. But I think he was talking about externally reflected light, if I remember rightly. So I think if my understanding of the judge's comments are correct, it at least takes away one of the elements of the radiance analysis that some of us thought was unsatisfactory, namely that there's the question of enforceability and the burden of having to maintain those finishes in the future, which I thought was not possible in law. So does the panel agree that that is what the judge was saying? And does that
I think what the judge was saying was in paragraph 153, and all he was saying was, if I paraphrase, that rights of light are rights to natural light, not reflected light. So what he was commenting on was the nature of the right, and the right which you have is a right to sky visibility, and not a right to reflected light. But those are the words he used.
Yeah. Yes, it was absolutely right. It's paragraph 153, Aidan, and it's very significant there that in final submissions, no doubt, Mark Wonnacott, as leading counsel for the defendant, said, as we all know, that the Waldron diagram was an artificial method, because in a badly lit room, which these rooms basically were in this case, most of them were, most of the daylight will be reflected light rather than what Judge calls this skylight, which is direct light, I suppose, and tenants in that building would not be bothered by the difference. However, and this is the crucial bit, counsel did not put this point to Jerome Webb. So the test was not carried out adversarially, but then the judge says, well, even if it's right that most of the light would be reflected light in the badly lit rooms, that's irrelevant to the question of whether there was an interference with Beaumont's right to light, which, as Andrew has just said, are rights in natural light and not reflected light. So we're all as we were, I think, is the position. Nothing's changed. We simply take into account the direct light that comes, from our sky visibility, etc. tests, Aidan. So I think if you wanted to focus on anything on a bit of light reading in the evening, it's 153 and 154 on this subject of the question of the elements of light, and also what we're talking about, the radiance test.
Great, thank you. Yes, I've got that in front of me now. I just didn't have it when I raised the question.
No, that's right.
But thank you for that.
Yeah.
Now, we have one further question from the audience, from Helen Anderson. So I'll let Helen ask her question now. Over to you, Helen.
Hi. It was just to add a comment, really. Under 253, it says reflected light is of different quality and less intense, and will be reflected only while the wall of yeah.
Oh, I think your line went funny during the course of that, Helen. We lost you towards the end. Could you repeat that?
Yeah, sorry. Just that the reflected light would only be relevant while the wall of Florala's hotel in the light well remained white.
Yeah.
No.
Yeah, I think, sorry, Helen, I just wanted to, do you mind if I just dive in here, the other members of the team? If I've got the judgment in front of me. It's, as we all know, a long and heavy read, but what this bit of the judgment is dealing with is the point, this was at the damages or loss point, there was a failure to mitigate. In other words, they could have, I think, enlarged or done something with the windows, and it was all to do with transom bars, which are, I think, windows or bars going across, and Alistair will no doubt correct me if I'm wrong. The bars go across the window, but I may be wrong in that. Anyway, whatever these things were, windows without transom bars, in other words, these presumably fairly thick things, it's also going back to paragraph 250. In fact, it starts under the heading, was there a nuisance? Was there a nuisance? This is also to do with the effect of the reduction in light on rent, so there was a causation point. And this was also dealing with Mr. Wonnacott, counsel for the defendant's point at paragraph 251, that what they could have done, what the claimants could have done, was to put in new thinner windows with less of a frame, and to put in windows without these transom bars halfway down. So I think it must have been the sash, what you call it, sometimes in a sash window, the bar going across, but I may be wrong on that again, Alistair, will out correct me. So it's the crossed bits. So you would get more light in by just having presumably a single glazed, piece of glazing, a piece of glass. Now, I think, Helen, therefore, when we come to your very right extract from paragraph 253, where there's a discussion there about removal of the transom bars, the judge did say, I accept Mr. Webb, that's Jerome Webb's evidence, that if you remove the transom bar, you might get more reflected light in, but not necessarily, that it would not necessarily, would get more of a view of the sky from the working plane. So that's absolutely, sitting at the desk, transom bar doesn't make much difference to the view of the sky above, when you're sitting at your 850mm desk. And then he goes on, and that reflected light is a different quality and less intense, and would be reflected only while the wall of Florala's hotel remained white. So that again comes back to the point I was making earlier about the potential changes to reflected light conditions in terms of the Servian owner painting his walls black or something. So, Helen, I think you're right. Actually, if I may say so, it's very helpful you've drawn our attention to that, because I'd forgotten about a bit about the transom bars. There's so much in this judgment of detail, but I don't know if your overall feeling, Helen, is that the exclusion of reflected light is the overall sense that we have here. Again, I'm very much inviting Alistair to comment on my answer to your question.
I mean, I'm entirely right. One thing to remember about the transom bar's argument is that what we calculate is the structural opening. We don't put in the window framing. So a sash window and a plate glass window are assessed exactly. What we do put in is structural frame. So if there is a structural mullion or transom to the window opening, that goes in. But if it's the removable timber window, then we don't include it. And I'm pretty certain the judge said that something of that in the judge did read something on that. So that makes a difference. The only thing I would say that's interesting on this case is the point we use 0.2% calculation is because Percy Waldrum assessed that was 1 lumen from the whole total sky and a dull. But Peter Defoe's study believes that it's a bigger amount of sky you need yourself of light out of than 0.2. So actually the argument, the radiance, is to try and do an argument about how much light you're actually getting from the sky on a dull day and wind, argue that you should use a different Waldrum calculation, but using the Waldrum method. And Peter's conclusion was that you need the sky to see 1 lumen of light, which would be dramatic on right to light negotiations. That's probably the better line to take.
Thank you, Alistair. Now we have just 10 more minutes left before our 5:30 end for this seminar. So I think it would be really nice to get on to the next question, as I don't think we've got any further ones at the moment from the audience. So we'll just move on to that question, then we can hopefully have an answer to it. So number 4, I recently advised the dominant owner in negotiations for a deed of release. I conducted the negotiations on the usual book value basis. I did tell my client that it might be possible to go for negotiating damages instead, but I discouraged her from adopting that course because it is uncertain and difficult to apply. Her neighbour now tells her that he also had a claim in respect of the development, and his surveyor negotiated a much higher figure of negotiating damages. My client now tells me that I was negligent in failing to advise her properly about negotiating damages and is threatening to sue. Does she have a claim? I should mention that a colleague in my company was acting for the developer, so the negotiations were between my colleague and me. My client says that she's entitled to see all of the communications between my colleague and me in the run-up to the agreement on the figure. And I'd like to put this to Andrew Smith, if I may, please.
Well, taking the end of the question first, that's another disclosure question. The client is not entitled to demand to see communication, the surveyor's communications prior to issue of proceedings, but if proceedings are issued, then it's all completely disclosable. I was interested in something Alistair said earlier on about the book value method becoming increasingly regarded as unreliable, but yet, I think Alistair said, still used quite frequently. And I think it is dangerous. On the facts of this case, the surveyor might very well get away with it, because the test as to whether or not, this is an oversimplification, but the test as to whether or not a professional has been negligent is determined by reference to the question whether a respectable body of professional opinion would have come to the same conclusion. So if this surveyor can produce another respectable and respective rights of light surveyor who could give evidence to the effect that the book value method remains a reasonable and dependable method, and comparable in terms of desirability with the negotiating damages approach, then he probably would not be held to be liable. When I say comparable in terms of desirability, what I mean is striking a balance between the ease of the book, the ease and straightforward approach with the book value, against the complicated, uncertain, and no doubt more expensive approach if you try to go for negotiating damages. So every case is different, outcomes are difficult to predict. If there were a trial on the issue, the surveyor would be asked to explain how he came to the conclusion he came to. And he would be expected to explain all of the disadvantages of the book value approach, and would no doubt be cross-examined in an attempt to demonstrate that actually he couldn't be bothered with the negotiating damages approach because that's too much like hard work, and the book value means an easy life, and in reality that's what he looked for. And all he did was to say to his client, it's all a bit complicated and difficult, you don't want to go there, when in reality he didn't want to go there. Now, if a surveyor were cross-examined with that intention in mind, and if Andrew Francis were doing the cross-examining, no doubt it will be revealed that actually this was a lazy surveyor who only gave that advice because it was easier for him. And one can't help suspecting that in a small minority, nobody in this virtual room, in a small minority of cases, some surveyors do take the easy route and shy away from the more challenging negotiating damages approach because they feel they're not confident. If the evidence demonstrated that that is what actuated the advice from the surveyor, then he would be held to be liable, and the damages, the level of damages, would be the loss of a chance of doing the better deal, which the claimant would say would have been available if that different approach had been adopted. So certainly my advice to rights of light surveyors when plumping for the book value approach is to make it plain to their client that there is another approach which might yield a better figure, but for the following perfectly rational and cogent reasons, in my professional judgment, it will be better to adopt the book value approach. If you do that, then you can demonstrate that you have applied your professional judgment in arriving at your conclusion. And as long as you didn't do something completely nuts, the application of professional judgment, even if it, with hindsight, turns out to be wrong, is not negligent. It's perfectly possible to be wrong without being negligent. But you've got to be able to demonstrate that you've thought it through and given the appropriate advice. Now, this was a bit of a sensitive case because in this case, the rights of light surveyor for the dominant owner was working in the same office as the rights of light surveyor for the Serbian owner, which I know can happen, which is which obviously gives rise to questions and gives rise to suspicions in the minds of your average layman. And if you do decide that it's appropriate for opposing parties to be represented by different people in the same firm, you've got to be absolutely certain that you can demonstrate that there exist robust procedures to ensure that there really is no communication between them and no means of information being leaked. And again, I suspect that where those circumstances do arise, if the two surveyors and possibly their boss as well were cross-examined about the nature of the communications which were allowed to pass between them, the cross-examination could prove an extremely uncomfortable experience unless the rights of light surveyors could demonstrate that there genuinely were workable Chinese walls which genuinely were respected. That case hasn't come up yet, but I think all rights of light surveyors should work on the basis that one day it will, and they need to be very careful, both in terms of proceeding with book value negotiations, and in terms where you have two people in the same company, of making sure you've got absolutely robust procedures to prevent any leakage of information.
Thank you, Andrew. Can I open that out to the panel? We've got 4 minutes.
Shall I?
Andrew, do you have anything to add? Oh,
Just to
Alistair,
vote-
sorry, go Alistair.
I mean, I agree with Andrew on this. We've acted on both sides of the negotiation before, with commercial clients who property developers who know what they're doing, and you can set the parameters by saying to do it on a book value basis using the following basic parameters. Are you happy that we do that? But you both want something, maybe a mutual rights or whatever, and you know where you stand. The other thing I would say is Chinese walls are difficult now with open plan offices and single document management systems. It is not always that easy to lock one individual out of a job file in a document system. So I think the warning is very, very apposite. I think to be to do it, and I think it should only happen when both clients are what they're going to and are what it is they're asking you to do, not necessarily lay clients who just think that they've found a trustworthy surveyor but don't understand how it works.
Yeah, the danger is much greater with lay clients, or particularly if you have one developer, obviously, and one lay client. That's a very sensitive situation.
Yes, I wouldn't recommend that at all. I think that if a developer long-term client, that is a very dangerous situation to be in, I think.
Mm-hmm.
Okay, thank you, Alistair. Now, I wonder if anyone from the audience has any point to raise on that. No, I don't think so. But that has, I'm afraid, brought us to the end of our allotted time. I would like to thank the panel very much for their contribution. It's been a great shame that we've not been able to do this in person, but I do hope that in the not too far distant future we'll be able to have another one of these at our offices, and of course everyone will be very welcome at Child and Child's offices. Now, if anyone has a question that you've not had an opportunity to raise, you would be really welcome to email that question either to me or indeed to Andrew. So thank you very much indeed.
Could I just say one final word? It's a great shame that we can't join you all for drinks afterwards and have a convivial time together. But I thought at least the least I could do would be to raise my glass to you. Which I just